Welcome to a live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation? Welcome to another episode of Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime. And today, that best guest is me, solo hosting. No rest for the weary. The COE, always trying to get camera time, had herself up there on the screen. We have the Shanna Gardner hearing this morning. Without further ado, you're looking right there at Mario Fernandez Saldana, the co-conspirator in this case. Our good friend Susan Harmon, True Lifestyles, is in the courtroom, and she said that this is going to have to I had to turn my phone off. I'm assuming Patrick Karate will be arguing Shanna's 8-4 vote for the death penalty. We're going to see if that's predominantly what this is about. No family yet, just a few media. COE, just stay on top of Susan because she's in the courtroom in Jacksonville. Mario's lawyer filed no motions to dispute the death penalty. That's what the meeting today will be about. Death penalty motions. You see the chair of Judge London M. Kite, a very fine judge in this case. Just saw Jesse Dreiser, Mario's defense, Christina Stifler, and Alan Mizrahi, the prosecutors in this case. For those who don't know what this story is all about, Shanna Gardner and Mario Fernandez Saldana, who is now her estranged husband, are accused of orchestrating a murder for hire plot to kill her first husband, Jared Bridegan. That again is Shanna's ex-husband. Jared Bridegan was ambushed. He, as you may recall, is a Microsoft executive. He was ambushed and killed back in February of 2022 after dropping off twins that he shared with Shanna at her Jacksonville beach home. He had remarried, had two new kids with his current wife, who's obviously now a widow, very sadly. Police say that a tire was placed in the road to force Jared to stop his vehicle, at which point a trigger man, who we now know as Henry Tenon, who pleaded guilty to all this, he came out at that moment when the tire was in the road, and Jared Bridegan went to check on it and shot and killed him. This all happened while the 2-year-old daughter of Jared Bridegan was inside the car. The child, thankfully, was not hurt, but it was a very, obviously, tenuous situation doing this with a young child in the car. The key players here, just so you know, he's already pleaded guilty. Like I said, Henry Tenon, he was a tenant of Mario Fernandez Saldana. And just this week, this past Monday, there's a money trail that was made public. And that's what people have obviously been thinking and wondering about. But there was payments made. Henry Tenon pleaded guilty to second-degree murder. And I'm just scrolling down here to check on the comments. Yeah, triple Qs for questions, please. But Henry Tenon pleaded guilty to second-degree murder. He admitted to being the shooter in this fatal ambush. He was a tenant, again, at a property owned by Mario Fernandez. He testified that he was promised $150,000 disguised as an investment in a pallet business for his role in the killing. Mario Fernandez is the one who we saw a moment ago sitting in the courtroom. He's Shanna Gardner's second husband, and he's the one who police and prosecutors say recruited Henry Tenon to commit this heinous crime, and that he controlled the financial accounts, that Mario Fernandez, in fact, controlled the financial accounts and the payments to Henry Tenon. Shanna Gardner, of course, she is the ex-wife of Jared Bridegan, and she is accused of being a co-conspirator with her estranged husband, Mario Fernandez Saldana, in this murder plot. Now, earlier this week, as I said, on Monday, today's Thursday, we found out that there were checks deposited into Henry Tenon's account. $2,000 check with the memo landscaping and clearing. A $3,000 check with the memo keeping up with the roof. A $5,000 check with the memo Kickstarter good luck. All checks here were issued by First Choice Home Rentals. That's a company co-owned by Mario Fernandez and Shanna Gardner. Space Coast chimed in earlier when we were off camera. We were talking. What's the deal with the paltry amount of money? So far, we've seen $8,000. Now, there was also a trust fund controlled by Shanna Gardner and Mario Fernandez. And from that fund, $5,000 were transferred in March and April of 2021. That's another 10,000, and then 10,000 transferred to a checking account in February of 2021. And then there's a $75,000 deposit from Shanna's parents in December of 2021. That's where it gets a little interesting. And we also just found out that Shanna's parents, who deposited $75,000, it appears, we don't know if they knew what it was for, but we now know it was used to kill Jared Bridegan. But those same parents are now in custody of the twins that Shanna and Jared had together. So that is a very twisted and sordid sort of side tale to this crazy story. This is incredibly reminiscent of the Dan Markel case out of Tallahassee, which is our original true crime case. And there we know that Donna Adelson is going to be going on trial. Now it appears that she'll be going on trial in June for the orchestration of a murder for hire plot. Her son Charlie already convicted, and here you go, right across the top of the Sunshine State in Jacksonville, you've got a very similar thing. It's just the method is different. The Adelsons hired a hitman who just went up and shot him in cold blood, Dan Markel, and change that shot a little bit. And then here they put the tire in the road as a diversion, as a tactic. He gets out, Jared does, to check on this tire, and that is when he is killed. This trust fund that we're talking about states that Shanna could serve as a trustee only. This is interesting, and then this is from the parents. So the trust states that she could serve as a trustee, but only if she had no further legal entanglements with her ex-husband, Jared Bridegan. So follow the money. It's always about the money. My dear mother says, Carm, if it's a money problem, it's not a problem. I think she's wrong on that one, because it seems like everything is about money and trying to get money and kill for money. Here it was obviously a horrible situation in terms of a custody battle. That's the other huge thing, obviously, between the Adelsons, Dan Markel, Shanna Gardner, and Jared Bridegan, was that they were all in a bitter custody battle. So again, Shanna Gardner is due in court along with the estranged husband, Mario Fernandez Saldana. It typically starts right on time. We're obviously going to take this live. Just a little heads up about the rest of the day. In 2 hours, at 11:30 Eastern, and I believe it is 9:30 Mountain Time, Corey Richens, the woman accused of poisoning her husband Eric Richens with 5 times the lethal dose of fentanyl, she's due back in court, and we will bring that to you live as well. Again, that is 11:30 a.m. Eastern Time. Yesterday, we're talking Luigi Mangione. We're talking the Alexander brothers here in Miami, all arrested. Today, it's women killing their husbands. So Steve Cohen says this country needs a check up from the neck up. Everyone in this country, the Gardners, this is KCL, knows more about this case than pretty much everyone except Susan Harmon. And I'd say that they're pretty much tied when it comes to knowledge on this case. The Gardners were awarded guardianship of the twins last week, and apparently an agreement has been reached for the Bridegan's to have visitation. Again, the Bridegan's are here in Jacksonville, as far as I know, and they are out in either Utah or Washington State. I believe it's Utah. So that visitation is a long trip to visit, and all these crimes, always Washington. Okay, all these crimes always affect the families in a major way with a complete ripple effect. Was a Home Depot involved? That's interesting. You know what? It's funny that you mentioned that. Yes, in the Corey Richens case, she was working at a Home Depot as a cashier, and that's where she saw Eric Richens, and then look at this. Wake Up Joel said that. This is enough for me to look at this. Wake Up Joel. I'm up. Yeah. Look at KCL. Corey met at Home Depot. So there is yet another Home Depot connection. There's no doubt that Home Depot is the true crime retail store of choice. People who commit crimes seem to always be in Home Depot. So the next time you're in Home Depot, look around. Be careful. All right. I'm awake. I'm going to do some jumping jacks, get my blood flow going here. We've got the seal of the great state of Florida, and we're waiting for Judge London M. Kite, who's late and therefore making my job a little more difficult. My friend Abby Crossing is here, selling tarps, not buying them. Yes, it's either you're selling or buying. Either way, it could be dangerous. Look at this. I have no idea what's going on. To be honest, I haven't followed this story at all, really, except headlines. But there have been drones flying over my home state of New Jersey. No one knows what the hell is going on. It's crazy. They can't get answers from the federal government. And these are like big drones that have been consistently and constantly flying over New Jersey. And I asked Rob D'Amico, who's our guest. He was with the FBI, and I had no idea. He was on some sort of anti-drone team, which I had no idea that existed. And I asked him because there were some reports that maybe they were coming from an Iranian ship. And he's like, do you think that if the Iranians sent over drones, they would have lights on them, which is kind of a good point. I don't really think that far down the road, but I have no idea what the hell those drones are or why they're over my state, but they better get to the bottom of it. All right. We're sitting here. We're waiting for Shanna Gardner. Of course, she's represented by Jose Baez, and I have no idea if he will be in court. He hasn't been the last couple of times. Thank you. Michelle saying great show with Josh last night. I was on with Josh Ritter after all of this. And look at this. Nicole watching from Plantation, which is right near us. COE, please handle that personal business we were talking about related to the back room. Needs to happen, please. Space Coast with a great question. Whatever happened to Amazon drone deliveries? Maybe they're over New Jersey. I don't know. Maybe they're all just stuck up, stalled over the great state of New Jersey. Here you go. I said I haven't been following the UFO case. I can't follow everything in the world. The UFOs are not really true crime. Look at this, a different spelling for Jose Baez. It's B-A-E-Z, but here B-I-A-S. I like to play on words. And look at Catherine coming to my defense, which is why I love her so much out in Maui. I don't know how she's up right now because it's like 4 a.m. there. Don't be so mean. Joel's been working his you-know-what off, his tail off. Oh, look at this. This happened right here. The Alexander brothers. There's Orrin, Tal, and Alone. The father owns a company called Kent Security, which is a huge private security firm. The brothers, two of these three brothers, went on to start their own real estate firm. They were super, uber, crazily successful. So successful that they helped close on a $229 million condo sale, apartment sale in Manhattan. Yes, there's an apartment for $229 million in Manhattan, and they were the ones who brokered that deal. The three brothers all arrested yesterday about. Glad you asked this, Ramar. All three brothers were arrested yesterday, accused of basically being Sean Diddy Combs, of drugging women, doing SA, participating in SA and R of the women. A horrific story. It's been, they say, an open secret in Miami. COE knows a lot of people who knows these guys. They're like 37, 38 years old, just slightly younger than me. And everyone said that they always expected this, that they are not nice guys, that they've been like this since the high school days, which they are accused of. They are accused of committing some of these crimes all the way back to high school, which is 20 years ago. So it's a big story. These are three, again, children of privilege, of wealth, here in Miami, and were successful in their own right, and then go on and basically just destroyed many people's lives, including their own. And they are about to face the American justice system. This is great. When are you doing a show about Sam Goldberg's response? We do need to do that. There you go, AC. I unfortunately see these are the comments. AC, hit us up, survivingthesurvivor@gmail.com. No one really says anything good about these guys, which is always a sign. And this is interesting. Oh, AC's got more info. So strange. Tall is not showing as being incarcerated. Orange hearing is this morning, and I'd be grateful if you covered it. COE, we need to at least record that, and we'll get back on it. It's going to be a short arraignment, I'm sure, but there will be, I guess, a hearing there. COE, please check on that. That's important. And we are limping into Friday here. Denise says it best. There should be a bumper sticker for this. Don't be a Diddy. Do not be a Diddy. Three brothers with the same criminal pattern. This is true. It's unreal. And the story, I think, it would have been a much bigger story. I was telling the COE if it wasn't for this guy Luigi Mangione. There we go. All rise and all be quiet. We're gonna watch together.
Be seated. Morning, Anna.
Thank you. Good morning. Good morning. I apologize about the delay. Good morning.
Mr. Clerk, Steve Siegel for the state, verse 14 and 9, Mario Fernandez Saldana, Chamber.
Good morning, Your Honor. My name is Jesse Rice. I represent Mr. Fernandez. I'm here with Shanna Gardner and my law partner, James Hill, and Laura Fernandez, President of the City.
Thank you.
Good morning, Your Honor. Patrick Brody for Shanna Gardner, President of the Court.
Thank you. Good morning.
Brian, just have it here also, Your Honor.
Sorry about that. I didn't see this.
Okay. Thank you. Good morning, Mr. Giuseppe. All right. What would the parties like to cover first?
Your Honor, we can start with the discovery update for deposition purposes. I filed this morning and have a copy for Your Honor bench. The discovery exhibit regarding depositions, and it outlines the notices defendants have filed and the names of all witnesses that have been deposed in the past calendar year. We completed our last round of depositions this week. There was one witness this week who was not served, but I was able to make contact with him. He's available to me here. I think the 10th round was canceled for service issues. Otherwise, I believe every witness that defense sought to depose over the past year was completed, other than 3 witnesses, 2 of which were not served.
Okay. What's the defense perspective on that?
I think we're cruising. We're doing a lot of work at an exponential pace.
What about, I'm concerned about the download that has, I guess, gone through, and Detective Simmons, you're here.
Yes, ma'am.
Okay, if you could come forward, please. I have. This is apparently a very tremendous undertaking, and so I'm appreciative of your review of work. Before I start asking you questions, what I'm trying to do is I'm trying to balance, like, obviously the defense has legitimate concerns about the information contained in these downloads. And so before I ask Detective Simmons anything, at the point in time that we stopped everything, and that the federal government and those agents analyzed whatever they analyzed, how much of that would Detective Simmons or whoever would be looking at it would be duplicating that work?
I'll let Detective Simmons speak to that. I'm not understanding, obviously, the forensic technological side, so to speak, of it. The Secret Service was able to complete it fairly quickly. We did receive filtered copies of all of the downloads and eventually of Google downloads and iCloud downloads. We no longer have possession of any of those. I floated some ideas with Defense Counsel this morning on how we could proceed with working in the interim while we have it refiltered. I think we all need to meet and put our heads together. Unfortunately, Mr. Mazzarati and I are in a capital case this week.
I understand.
My suggestion would be, and I'll let Detective Simmons speak, I don't know if the Secret Service had different equipment, which they were able to do it. And I'm not an expert by any means, but I do have knowledge and experience with Celebrite and Axiom. I thought it would be as simple as they could just remove that data before giving us the extraction. And I believe that's what Secret Service did. Detective Simmons can speak as to whether that's feasible or not. In the interim, my suggestion to Defense Counsel has been that their forensic experts can meet with Detective Simmons, make copies of the unredacted versions of their respective clients' devices, that the state of Florida and the alternating defense team, while we're potentially having somebody else do this filter process, could have Detective Simmons as the independent arbiter just request information we need that we know is not attorney-client privilege, that you can provide, not the raw data itself, but clearly when you have a Celebrite extraction, you can extract a PDF of text messages between whoever. For example, if I wanted John Doe and Jane Doe's text messages only, and those are 2 civilians, I know they're not attorney-client privilege information, Detective Simmons could extract those text messages, provide me with the PDF extraction report of that data, hand it to, let's say John Doe is Mr. Dreiser's client, give it to Mr. Dreiser, he would look through it, confirm there's no attorney-client privilege, and then forward it to the state. That's the best I came up with. We obviously haven't all agreed upon this. I think the Defense Counsel is open to this idea, but I will let Detective Simmons speak to the actual tech side of it, because I'm not understanding whether the Secret Service had different equipment or why the extraction of the actual raw data can't be done.
Okay, before I do that, the state is no longer in possession of these reports. Is that what you're telling me? Like,
I don't have the device extractions. No, I don't have the device extractions for those, or the parsed data from the iCloud or from Google, from Apple or Google.
is the defense in possession of that? The reports that were initially done, that you all filed the motions, are y'all in possession of that information?
Yes, we are. There are multiple versions with different sizes. We're still trying to figure out why that is. But the answer is yes.
Correct me if I'm wrong, at one point in time, I thought that the defense was given complete, unfiltered access to this information. Do you have that?
Yeah.
You do?
Right. But there's
Okay.
that in
You
it.
need, look, Mr. Greiser, you need to look behind you.
Oh, I'm sorry. Well,
Okay, why don't you just answer, you don't have to tell me. So,
We only have the full unredacted Google for, Mario specifically had 2 Google search warrants. We have the full unredacted version of the second warrant return, but not the first and not of his software. No, they got their own. We didn't have that.
okay, so what was the file that was shared across the defense, like that, I believe it was Mr. Fernandez's information that was somehow shared potentially inappropriately with Ms. Gardner's team, and then there was some emails saying, don't open those. What return is that?
That was shared via NextPoint, and
But what,
that was a result of the second Google return for Mr. Fernandez.
and that's what you have full access to?
Yes, with the caveat that we had only had access to NextPoint for about 2 weeks before it was shut down. So there could have been more of those weeks only reviewed so much before it was shut down.
Was that how you were accessing it, is NextPoint? And so now y'all don't have it anymore?
Since NextPoint was shut down, we got unredacted copies directly from the Secret Service, but only of the second Google return, not of any of the other returns or devices.
Okay. And there is a first Google return that relates to Mr. Fernandez.
Yes,
He also has 2 devices, correct?
Mr. Fernandez only has one cellular.
Okay, Ms.
device.
Gardner is the one with multiple devices and a iPad or an Air or something,
Laptops,
laptops.
watch,
iPad.
pads,
She has, I
phones.
think, approximately 5 devices as well as an iCloud return. However, we weren't able to access all. I say, either Secret Service, they weren't able to actually, I don't know what the technical term is, break into some of the devices. So there were extractions completed of some of those devices, not all 5 of the devices. But those devices themselves are still within the custody of the Jacksonville Beach Police Department in their property room, because those devices were sent to Secret Service. I'm not sure at this point whether they're in the property room or Secret Service. But my law enforcement officers clearly are taking our orders very, very seriously, and nobody wants to open anything, touch anything, look at property, so.
What does Ms. Gardner have?
So we have multiple copies
Of what?
of her phone, her cloud. Our intent, though, in trying to work with the state, is to have our own expert go and actually get the raw data and verify that we have a complete copy of what came from the device. So we've been working with the state to try and work that out, to get our expert to actually be able to do his own extraction, so that we can be confident that we have 100% of the data that is on the devices seized by the state. Right now, I cannot assure the court that that is the case until our expert goes and looks at the devices and actually verifies.
What form is this in? So you
So
say I have 5 devices, you don't have a physical, so what are you looking at
hard drives that were given to the state
that were downloads?
that were extraction. And
By who?
well, Secret Service gave us a hard drive that I brought over early on in the case before Secret Service sort of bowed out.
No, they were
Yeah, I understand. Yeah, so that's what we have.
all told.
Right, yes, Judge. So that's what we have, but again, Judge, I do not, on behalf of Ms. Gardner, I cannot tell the court that we have all the raw data from the devices until we actually look at our expert looks at the devices in comparison to what we have. We've been trying to coordinate that, and that's where we're at. And we believe that at the end of this, the process that the court, beginning with the motion to disqualify the order, said that there would be a new filter process. And then the court has issued 2 orders, right, about that filter process. It was our intent to have our expert go and get a complete copy of the raw data from the devices. And then we would have the data that the state would presumably have from this new filter process. And at the end of the day, in preparation for trial, those were going to be the 2 sets that we were going to work on at trial. And so that's the way that up until recently, we saw this case working out as far as the devices.
And of course, I can only review for my preparation of trial Ms. Gardner's devices once I have confidence that there's no attorney-client privilege.
Right.
So, and I believe there could be exculpatory evidence as well as strategic, all sorts of evidence that we may need in our case in chief that could be found on her potential.
The issue with that is that, and I'm sure that they deal with it in federal court all the time. So if we think about this evidence as a whole, right? The way that I was reading the cases that are reviewed from federal court, which they deal with this situation all the time because of the nature of the allegations that are made against people, like attorneys and all kinds of, that generally have this type of issue. This doesn't come up in state court a lot. Anything exculpatory, all right, to either defendant, if it is contained within something that could be confidential, would not necessarily be the burden of the state to disclose because they wouldn't have access to it.
Well, I know, let me be very clear. I agree with you.
And
I'm not entitled to use it, it's confidential. What I'm saying is, I can't make the determination of what I may, from what I am allowed to use and what I'm allowed to review. I have to be given a clean copy at some point.
a redacted copy.
A redacted copy, a clean copy, meaning one that I'm confident has no attorney-client communications or privilege or problem. And that's all I'm saying is, once he gets his extraction, Mr. Brody and his team, and once they are able to do it, that doesn't help me. And once I get our Google extraction, and once I am able to review it and confirm that there's no attorney work privilege and product and communications, that doesn't help him. So isolating it, it sounds like is one of the ideas I think is problematic. Am I not being clear?
No, I'm thinking about what you said. All right, I have some more questions. Detective Simmons, explain to me what the issue is from your perspective.
So my issue is that we have limited software in my lab. We're a very small lab. I don't have the software needed to handle this magnitude of data. I've never, in my career as a digital forensic examiner, never had this magnitude of data.
What does that mean?
Magnitude of data.
Right, like what are you talking about?
Multiple, a lot of data, like gigabytes to do a redaction. I've done minimal redactions for small cases, but nothing to this magnitude.
Talk to me in numbers. So
I'm talking gigabytes, terabytes of data that I would have to go to computer storage.
is it a software issue or is it a manpower issue or both?
It's both.
So even, I'm just asking questions. So even with the court entering the order the way that I did, you would not have to review, instead just search. certain terms, certain numbers, like that is not workable for you. Is that what you're telling me?
That's correct. I tried that, and
What happened?
it flagged, I had to go through every individual file, and there was still like 4,000 or 5,000 files that we never redacted.
So you put in the search term, it flags it, and you did what?
So I put the search term in, and what it does is it would bookmark those items and say it needs to redact that. I need to take those out. So I would exclude them from the report. But then I started looking more into the files, and it wasn't redacted.
It was not redacting. Your software
My
was not.
software was not.
What software are you using?
So I am using Cellrite.
Is it the latest version of it?
It's the latest version. Manually, but you have to, there's so many files inside there, worded different ways by different names. You have to visually go in there, each file, and redact it. And that's where it's taking, conservatively, that's where I said, at least a year.
All right.
That's just conservative.
Also, in the email, you indicated that you did some research about other private labs that would do it. Who is that?
So there's a lab called Crow LLC out of Sarasota, Florida. I can email the court all the information on that.
Well, it's not me. It's the state. If they want to look at it.
They handle this magnitude of requests.
Okay. Well, what's the state's position on Detective Simmons? Like, obviously, he couldn't, when he agreed to it, he didn't know. So I don't have any problem releasing him, and we'll go back to the drawing board.
I think.
Do you want a minute?
I want to discuss with the defense counsel alternative ways. The state, I'm going to discuss this at length with him or with anyone else. Obviously, I'm not just communicating with him outside of the court. So I don't believe the state of Florida should bear the burden of the cost of doing this solely. So that's a consideration if we're going to seek a private entity through a private lab.
I'm not saying that. What I am saying, okay, so in my mind, there are a couple of solutions. All right, that's why I was asking, what do you all have? Y'all went through an entire process that started from the outset of this case until the point in time that problems started to arise. The court's orders were not intended to frustrate the process or duplicate any work. Y'all have already deposed, in my mind, witnesses that normally don't comply with state subpoenas. Y'all have found out certain information. I don't know the level of cooperation that the federal government is giving the state. At one point in time, it was not very good, or there were lawyers involved and things like that that were frustrating the process.
I don't believe that's true. I don't think the federal government was frustrating it. The agents themselves who worked with me on this case were always, I feel, extremely responsive to my request to speak with defense counsel, complete depositions. I know Mr. Curdy and I had multiple conversations with the ATF and ATF counsel, and neither of us got the impression that they were intentionally trying to frustrate the process or not.
No.
That they had concerns.
You're misunderstanding me. What I'm saying is that this is a reality of the situation, okay? They can do their work when they are required by state law to answer questions that the defense is entitled to ask them. They potentially, and y'all correct me if I'm wrong, it is a defense concern that agent would then share information that would necessarily be appropriate to share because of attorney-client privilege. And so then, when I'm saying frustrate the process, it's a reality of this is that they don't have to comply with state subpoenas. They don't, the defense, which happens, like, I think the governments do try to cooperate, and I'm not saying the agents weren't cooperative, they have been cooperative, but the lawyers for the agents sometimes stop because of their confidentiality deep issues, their investigative techniques will stop something that could be discoverable in a state sense. Do you understand what I'm saying? So that's what I'm saying is frustrating the process. Their laws and their concerns are different than state laws, state concerns. And then later on the fact that we're asking them to do something kind of that they would normally do, but they have a process for that. Honestly, it's been criticized by some federal courts, that process, but I don't have any, I'm gonna let you all discuss this. I'm not gonna make any decisions today. What I'm thinking, and I'm just thinking out loud, this could be a possible solution, okay? Which is we revisit the same agents that have already been involved in the case, have already done work on the case. I enter a taint order with their agreement, that would be lawyer's agreement, their lawyer's agreement that they would abide by the state order, which they normally would not have to. But they would abide by this process to be a filter team. That is not communicate with the state of Florida and all those other things that I was asking. That is one option because they have already essentially done work. Apparently they have the ability and software to do the work, and it essentially costs no one anything except for their cooperation level. That's option number one. Option number two is that we revisit FDLE. I'm not exactly sure why they somehow circumvented a court order and were just, I don't know. I mean, it was just the state kind of talking. The Florida Department of Law Enforcement maybe in conversations, and what I'm saying is like all lawyers get on the phone with Detective Simmons. He can maybe explain something that the lawyers can explain to potential new forensic examiners and say, can you do this work? And I'm not, I mean, we are under a time frame. I have set a trial date. I do want it accomplished. I don't want it to duplicate work, but it sounds like the defense does not have whatever you have. And I would hope that I mean, whatever y'all want to exchange as far as it, there is no problem giving them an unredacted copy. What is the issue? I hope that it would not frustrate the defense preparation that they could get whatever copies you wanted of unredacted information, separating their clients, and then we go through the state's ability to view their own evidence. That's
In that vein, I just want to highlight that what Detective Simmons has brought to your attention is not something that you haven't heard us saying since the very first court date. But it does highlight how much discovery is in this case. And the very issue that Detective Simmons ran into is what Shannon and our office is running into on a daily basis of work to do in this case, which is we put a search term in or we're looking for certain evidence and then thousands of files, and then she goes one by one by one. So, and I'm not asking for a continuance by any stretch of my argument today, but I am bringing to the court's attention that it's not exclusive to Detective Simmons' assignment.
Mr. Dreiser,
And our office has not the resources that perhaps even the Clay County Sheriff's Office.
I've never questioned that. I think that what I am questioning / directing per the rules, we have got to get this into some type of usable format. Okay, we just can't we can't keep spinning around and it's so much evidence. At some point, we have got to come up with a plan. And as much as you need court intervention, I'm going to do it. And as sensitive as I am, like y'all have brought forward, in my mind, good faith issues that I'm trying to resolve. But I can't keep passing this case weeks / months without some kind of plan. And so if I have to see this case every week and I have to ask these types of questions, I need to get this in a usable form. It's the state's evidence. I need to get it into a usable form, honestly, for both defendants, and the state needs to have access to their evidence. And so I'm not foreclosing an idea, but we can't, I'm not going to pass this case without some kind of plan. What I'm trying to do today is get some, because this is the second court order that cannot be complied with because of the nature of the evidence. And so just bottom line, we need a plan. And so that is what we're going to accomplish before the end of the year.
And I just want to suggest and reiterate that the court has come up with plans. The defense has not frustrated those plans.
No, I'm not saying.
I know you have it, but I just,
I'm not saying that you have. I'm very sensitive to what you all are going through. That is both sides.
I think, and the state and I, we have discussed, and not to belabor this, this is what we're going to do in the next few days. I think it's going to have to be some scenario in which the state picks their evidence and says, this is what we're going to use. They get it specifically extracted to them, to Detective Simmons to review. They give it to us, or Detective Simmons gives it to us for our review, that we agree, and then there's a timeline and a deadline. That's it. They've chosen what they're going to use.
That is not going to work. That is not going to work. It is not going to work because you all, rightfully so, have said that they can't touch their evidence per court order. They cannot. They can't choose it. They can't look at it. Instead, to me, this has to be a backwards process. They have collected it. It has to be independently reviewed. You all look at it. And you all get to object/litigate it. They can't say, Mr. Dreiser, evidence A, this is what we're going to use, because evidence A could contain all kinds of things that you don't want them to see.
But what if they said, and I'm not suggesting we're agreeing, this is what we talked about, just so it's clear with the court. What if they said, we want text messages between, from Shanna Gardner's phone between January 1st and December 31st of 2022, okay? And then they don't get to just get it. They say, that's what we want. Then Detective Simmons specifically extracts that data. He reviews it, that it's clean. We confirm that we agree with Detective Simmons. We raise any objections that we disagree with Detective Simmons with the court. That process plays out, and then it's clean. The court determines, the defense agrees, whatever the case is, that's clean evidence. Then the state gets it. And then what I'm suggesting is, so it did, it went backwards. They didn't just pick and choose what they wanted and get to look at it. They looked at it after it became reviewed by a Taint organization. And at some point in time, the clock stops. And the court says, you pick and choose what you wanted, it gets reviewed, and that's it. So on the eve of trial, they can't search term, find something. That's what I was suggesting. So it did follow your process, if I understand your process. It just did it specifically and not categorically, which categorically is what Detective Simmons cannot do timely. But I think specifically, again, not putting words in Detective Simmons' mouth, I think what the state and I talked about, assuming that we're correct, and Detective Simmons says, yes, I could do it individually like that, that could be a solution. Is that what you understood me to say? I think there's other issues with exculpatory evidence, but putting that aside for now, that may be a solution. If you said it absolutely isn't, but I want to make sure you understood what my process thinking.
I think we should have these discussions off the record. Defense counsel and myself, and we come up with some plans rather than standing here and just giving back and everything.
I believe that I'm not having any off-the-record conversations. This is a capital case, and I'm going to tell you all what I think, okay? Which is, I'm going to allow you all to talk and potentially come up with solutions, okay?
That's what I meant by off the record. I didn't mean court, I meant the counsel.
what I'd like to do is, I think that the amended order that I put into place for Detective Simmons is a better version of what I put into place initially. So what I'd ask is that you all review that, and not review it like in the sense that this is the final word, because we are working through an issue that just generally there's little to no guidance for state courts. There is federal guidance, but we don't have the same resources / laws, okay? So if you all see something that needs to be changed within the order to get this evidence examined without exposing information that is not appropriate to the state of Florida, I'm open to that, is what I'm saying. So you all can talk as much as you want to. My suggestion would be that you include Detective Simmons with all sides present, so that whoever you all are thinking about, that we don't get ourselves in this situation 30, 60 days later. Second thing is that as far as what Mr. Dreiser is proposing, it may be a very short-term solution. I don't think it is a solution in totality. Ms. Gardner, I'm looking, and Mr. Fernandez are charged within a date range. So like saying, I just want text messages within that date range for either side, in my mind, is dangerous, because if you isolate just that time frame, and let's say, for argument's sake, there is something exculpatory outside of that date range, and then, there is post-conviction after this, that just automatically undoes everything that would happen in this case. So I don't believe that because it has been collected, it is a part of this case. Because it is in property, it is a part of this case from this day until the end of days, okay? So this evidence has to be examined in totality. There is no scenario where y'all can isolate a certain period of time that sometime in the future it wouldn't necessarily be relevant. I think the defense is running a risk, and I think the state is running a risk. So while it may get you all started, I do not believe, okay, that it is a solution to this issue. This evidence, in my mind, has to be examined in totality. The defense has to be provided the information in totality. The state is entitled to something that is not privileged in totality. And so you've got to come up with a plan to get that accomplished. And I'm willing, and I know that you all have been saying it since this has occurred, but what has happened is that we have not come up with workable plans. And I don't think any of us have dealt with this before. So I'm open to ideas. I'm open to re-examining those orders to get this accomplished, is what I'm saying. I'm willing to work with the parties to get this done, but we're not gonna go weeks and weeks if we have to come back every week with more questions, more solutions. I don't think that it's a good use of time saying we've got problems, we've got so much evidence, That's never gonna get this accomplished. So, I'll see y'all next week. Long story. So I've got 2 trials next week. I have Friday, if y'all wanna come. I'd probably be sending the jury out. I can come. He can be on Zoom if you want.
Mr. Hill and I are both out of state on Friday.
Okay.
Detective Simmons is out next week as well.
Then you're out next week. I want to get something in place before the end of the year. When are y'all coming back? Are you done until January?
I'm out Wednesday to late Sunday night. I have to be back Monday morning. I think Mr. Hill is the same.
Detective Simmons doesn't have to be here. I do need a conversation with Detective Simmons to occur between the parties.
Yes, Your Honor.
But I hope that I was clear. Mr. Drexler, I'm not totally excluding your idea, but I think that I'm hoping that I'm explaining my concerns about your idea so that.
You're right, you're right.
Okay. I don't hear that often.
I said, and I guess
Right, this was.
Okay.
I said to the court that excluding the fact that I also am entitled to his review and he's entitled to mine. I did throw that in there because I agree with you. But at some point, Mr. Carodi has whispered in my ear, this is a resource issue, and I am just spitballing ways to accomplish the goal. And you're right, it's a post-convict. The bottom line is we need to go to the drawing board. We need to have a plan. The defense has always been in agreement with that. And
Has Ms. Gardner retained an expert?
Yes, we have, but Judge, in all, so first of all, I don't know how any burden of this can be shifted to the defense.
I'm not.
I know.
Where'd you get that from what I said?
Well, not from what you said, from something that the state said earlier, that we should not have to, that they should not have to bear the cost.
I disagree with that.
Okay.
So let's move on.
And I just want to remind the court that when the feds do this, and they have substantial experience, they talk about a team. And why do they talk about a team? Because they recognize that doing this in big cases is a Herculean task. And from the outset, I think that having one person do it and relying on that one person as a collateral duty, right? Because detectives can volunteer to do this. That's just not going to fly at the end of the day in this case. It's just too much. And so there has to be, from the state of Florida, right? The state of Florida, the entire state of Florida, there has to be a resource effort on their side. If they want to use this evidence at trial against our clients, they have to dedicate the resources to get what has to be done under the law. And I don't know if there's anything that I can do on behalf of Ms. Gardner to get the state to dedicate the resources that Detective Simmons has clearly made need to be allocated.
I agree with you. That's a fair point. I want to send you all off with as much guidance as I possibly can give. And I think that is a fair point. It is generally a team. It's multiple people conducting this type of investigation.
It's a full-time job. Like, that is their assignment. That is their full job until this gets done, every day until it gets done. And that is how the federal government does it. Because they recognize how much discovery in big cases they have to get through. And whether you're talking about cell phones or you're talking about hundreds of thousands of pages of documents, and they have to look at every page. And so I'm sympathetic with Detective Simmons when he says there are thousands of pages of things he has to look at. That is not unique to a team.
Okay.
This is a resource issue at its heart, that if the state wants to use this evidence, they need to do it right, and they need to put the time, money, and people on it.
Okay, I agree with that. That's a fair assessment of what's going on. In light of what, in my mind, the goal date would be, which is a trial date. With those parameters, and I don't want to leave the state thinking that it's somehow appropriate. Like, I do think that they should get the unredacted copies, right? But to have their expert go through it and then somehow disclose that can't be the flow. It has.
This is an interim suggestion, so all parties can continue to work on discovery.
But
While we do this, while we find a new team, I'm fully on board with what everybody's saying. I'm going to suggest we come back January 2nd so that I have time to speak with Detective Simmons.
Court's not in session, unless Mr. Hathaway wants to be in session. Is the clerk's office even open that day? I don't think so.
Well, we can pick a different day.
We can do January 6th.
Yes, ma'am.
I want to send you all, this is not necessarily my goal / wish. When January 6th hits, okay, that's 10 months from a trial date. In my mind, and I told I don't want to make Mr. Dreiser come undone. I'm open, okay, to moving, however, we are going, and that it is not a wish or a hope, we are going to have a plan for this evidence. And big cases with a lot of evidence is just, I know that y'all have been working very hard to, move through the witnesses. If I had, I know y'all have been saying it, but if I had known this is caught, in my mind, this is causing so many problems, because we have a significant amount of information that has not been gone through. And then if it is finally examined, it could relate back to things that have already been done. And so then we will be duplicating work. And that is, if I had known, okay, I would have probably, let me just say this. We are going to have a plan in the beginning of the year. You all talk with the guidance that I've given you. The plan that y'all come up with does not need to be a temporary solution. It needs to be a totality of the evidence. I think that in the interim, while y'all are over the holiday break, the state, y'all need to, whoever you want to get to see if you have, per your client's search warrants, if you can make arrangements to get that evidence from Jack's Beach, and then y'all will have that, and then you can wait for the filter reports. To me, that the first step in this process is for them to have access to the evidence unredacted, because they can't necessarily, in a timely fashion, comply with the order that I put into place, because I think I gave y'all 15 days. I can't remember. I think I gave y'all 15 days to review the redacted report, if I'm not mistaken. And I would be open if y'all needed more time in light of what's going on. But they need the unredacted copy to make sure that if they do identify certain things that are privileged, that it's not contained in that. So y'all need to get access to that. I had no idea that you don't have it anymore. So at a bare minimum, over this break, you all need to get that evidence unredacted. Okay. And Detective Simmons, maybe before y'all leave, you can meet, I don't know what y'all will need, if that can be communicated, what they will need to get that information, so that they can at least have an unredacted copy, and then we can work on the redaction process. So to summarize, maybe the federal government that's already looked at this, maybe there's a hard ask by the state of Florida to dedicate FDLE and team members. Maybe a larger agency down south that has little to no involvement with the state of Florida, like a Miami-Dade or a Broward County or something like that down there, where they can dedicate multiple officers to go through this information, do the redaction process, and give it over. I would prefer a state agency, just because we are used to operating under the same laws, and they don't have the same protections as the federal government. So those are my thoughts, okay? And I did get, just to wrap this up, I did get the, some of the capital motions. I do appreciate y'all starting that process. I'm sure there are more to come, but I do appreciate y'all starting that process, okay? All right, I appreciate y'all's work. I will see y'all back January 6th.
Judge, one more thing.
Yes.
If I may, Judge, you had mentioned at the last court hearing you were going to issue order regarding Detective Johnson's grand jury testimony.
I'm sorry. I apologize. I will get that out.
Yes, Judge.
I'll put a note.
January 6th, Your Honor.
Yes.
Have
Thank
a great
you.
holiday if I don't see you. Thanks for your hard work.
Thank you.
I think, Your Honor, maybe it's you.
Yes.
All,
Katie, I'm going to look into what I can provide you, and if I can, I'm going to get that to you.
There you have it. Mario Fernandez Saldana, the estranged husband, who's one of the masterminds of this, walking out. I think that was Shanna just before him. Interestingly, he is in a jail jumpsuit. She was in civilian clothing. It looked like she had like a light peach shirt on. If I was looking at the right person, it was a little tough to tell. But this was let's see, True Lifestyles. She was in the courtroom telling us it was intense. True Lifestyles, if you can, just let us know what your take was on all this. There's honestly not that much to discuss. Basically, the defense and the state have been at total like loggerheads over discovery. At one point, the defense is accusing the state of looking at privileged information. So now they want all these. Shanna was laughing and flirting with Karate. I'm not sure which one it is, but there it is. Shanna Gardner facing the death penalty, charged with murdering her ex-husband. True Lifestyles again was there. You can hear she was flirting. No real, I guess, surprise there. However, this really comes down to an ongoing battle between the defense and the state over discovery issues. And specifically, at one point, the defense wanted the entire prosecution removed because the defense alleges, had privileged information that they were looking at that only the defense was supposed to be able to see. It was privileged client information. So again, they asked for the state to be removed. That was squashed, not allowed, quashed and or squashed. And so now it is a battle of who handles this to make sure that everything is kosher. And so at the end here, the judge, you could tell she's really irritated. We're going to have a plan for this evidence, she says. The defense, again, has accused the state of looking at this privileged information. There's a significant amount of discovery, the judge explains, it has not been looked through. And then she says, let me say it this way. We'll have a plan at the beginning of this year. Let's see here. Oh, sorry. Just put that. That was just stuff from True Lifestyles. Just a ton of court docs drama. This may delay the trial. Duval isn't equipped for this. Next court date is January 6th at the beginning of the year. So the bottom line is the judge is annoyed, and how much blame we can lay with her, I'm not exactly sure. Susan Harmon have a better idea of that. But basically, this happened 2 years ago, and they're almost kind of exactly where they began. So that's why the judge said, we're going to have a plan at the beginning of this year, and then said we might need another agency to step in and help. At one point, I think she even mentioned SLED, which is South Carolina. But then it was FDLE, which is the Florida Division of Law Enforcement. They're kind of the independent arbiter of things in the state. So she's saying, well, maybe we need an outside agency like FDLE or Miami-Dade to come in, which is where I'm at. And then the judge said she would prefer a state agency from within Florida to deal with all this. And again, the next hearing is January 6th. The bottom line from this hearing, the headline is it was a cluster. They're not organized. The defense is fighting with the state. This has been going on for a really long time, and this is a capital murder case. So it's obviously, you see that, facing the death penalty. So it's something like they've got to, they've got to get their ducks in a row. Everyone's pointing the finger at everybody else. As Steve Cohen says, don't point the finger, point the thumb. They just got to get their act together. True Lifestyle says Shanna looked like she gained weight, looked very disheveled. It happens in jail. Again, I'm not fully understanding why her estranged husband has to be in a jail jumpsuit and she gets to be in civilian clothing. I mean, there's no jury there, but still, it seems a bit unfair to the person with less means. Mario looked pissed. Shanna was laughing and smiling. He might be jealous that she's now flirting with her defense attorney. Kelly here, I agree with you. Disappointed that Shanna's parents got custody of the children. Life is definitely not fair, and they're literally across the country from the Bridegan. So that's going to be a long haul as far as visitation rights. So he has not been convicted. Someone's asking. The trial has not happened yet. Henry Tenon is the alleged trigger man. He has cut a plea deal with the state. He admitted to taking part in this. I think he's going to get about 15 years, but he's going to be state's witness in this. He's going to be a big witness, obviously, for the state. And so he is the big calling card that the state will use. But again, the defense annoyed with the state, and it's gone back and forth. We've covered maybe 2 or 3 other hearings similar to this, and nothing has happened. Nothing has gotten done. So now the judge is putting her foot down, and they're due back in court January 6th. And I'm hoping then that we get an actual, legit trial date, like that could actually be followed through on. Up to this point, it seems like everything just is muddled and keeps getting pushed all over the place. One other thing of note, the defense attorney for Shanna Gardner is the very well-known Jose Baez. He has not been in court. Some say he's making several $1 million doing this. I would love that job where I don't have to be at my job and get paid millions, but he was not there again today. We are coming back in an hour and 19 minutes. You got Corey Richins, Kouri, out of KCL's home state, Utah. And they're supposed to be doing scheduling, putting together a trial date, and setting things up for that trial. She's accused of murdering her husband, Eric Richins, with 5 times the lethal dose of fentanyl, and then writing a book about grief for children, going on a TV show and hawking her book after it has now been revealed by the state that she's actually the one who killed them. KCL, my pleasure. I hope I see you during Corey Richins' hearing. We are just monitoring different avenues of breaking news. But for tonight, the idea I had for a show, just this past week, you got Luigi Mangione, another lawsuit, by the way, who comes from a lot of money and is now accused of killing the healthcare CEO. We've got Diddy with yet another lawsuit. And then yesterday, 3 very wealthy, attractive brothers here in the great state of Florida who have a massive real estate business, which was helped to be developed through their father, who owns one of the largest private security firms. Well, the 3 brothers were arrested in Miami for all sorts of lewd and lascivious behavior, very similar to Sean Diddy Combs. Are accused of drugging women and doing the worst of things, despite these women's pleas and cries for help. So tonight, I'm thinking of doing a show about rich and reckless. What is going on here with these people with a lot of money and using their power? I'm thinking of just bringing 2 psychologists on and an FBI agent to talk about the investigative side. Let me know what you think of that. STS Nation is as much a part of this as we are. So, let your voices be heard. If you have another idea, bug the COE, Surviving the Survivor at Gmail. Yes, Nicole, it is blistering, 71 degrees here. I can't take it anymore. It is supposed to warm up, though, I just read. Ned Smith likes my title. I came up with it this morning, Rich and Reckless. There you go. So maybe that is what we will do tonight now that I have Ned Smith's blessing. For now, I'm signing off. I will see you in an hour. And what is it? I can't even think. 45 minutes. What's an hour and 15 minutes? I have to do the math in my head. I'm helping my kids now with elementary school math, and it's torture, absolute torture. And then I give it to the COE who's got a much higher IQ, and she's like, I can't do it. I don't understand it. So bottom line, my kids are screwed. Shanna Gardner is probably screwed. Mayor Fernandez Saldana is screwed. Corey Richards is probably screwed. And Shelley says, Joel, don't tell the people to bug the COE. KCL, love your titles for these cases. Thank you. Ooh, I like this even better, Ned. Rich, reckless, and ruthless. Make up the thumbnail, COE. We're doing it. My son is homesick. Little Judah Mack. I feel bad. And today he's got his trophy ceremony for T-ball, which come hell or high water, I'm taking him. He's supposed to have practice, and then that. I'm not going to make him practice, even though I should to toughen him up. But I'm going to let him go to the trophy ceremony because he deserves his trophy. Corey Richards, 11:30 a.m. We'll be back. Love you. Nikki Cuds is right. Elementary math is the hardest. Long subtraction, long division. My kids are like, what the hell do we need to know this for? And I said, I have no idea. But I guess if you're at a restaurant, you want to figure out your check, it's a good idea. But we all have cell phones. So I said, it's basically all a waste of time. They like that answer, but the COE didn't. Anyway, time to get some coffee. That makes me crazy. But I'll see you guys as I continue to ramble. I'll see you at 11:30 with Corey Richards. Love you, America. Let's get justice for Jared Bridegan.